Hello, good evening, greetings and salutations. Today is Monday, September 16th. It is 5:39 p.m. and this is our Legal Contracts and Board Policy Committee meeting. We will start with attendance. So starting please, Co-Chair Sykes.
Present.
President Autry.
Present.
Superintendent Robinson. Ms. Carter.
Present.
And Mr. Henshaw.
Present.
And Attorney Kepchar.
Present.
All right. Thank you, everyone, for joining us this evening. First item on our agenda is our previous meeting summary. As we review the previous meeting summary, if there are any discussion items from that. As there appears to be no discussion. Thank you. And the committee should move to approve the summary minutes?
Thank you, Madam.
Yes.
Thank you, Madam Chair. Yes, I move to approve the summary of the last committee meetings of the Legal Contracts and Board Policy Committee meeting that took place on Monday, when did this meeting the last meeting take place? So, August 19th.
All right, thank you. And Co-Chair Sykes is moving to approve our meeting minutes. Do we need to second them?
Yeah.
Okay. Will somebody second the meeting minutes?
Since there's only two real members, you would have to second
Me?
that.
I will
Yeah.
second. Okay,
Yeah.
I second.
Yeah.
I believe this is a good representation of the meeting that occurred on August 19th. Thank you. And because this is the first time we have done this with the meeting minutes, is there anything else we need to do with the meeting minutes before we proceed? Wonderful. Next on the agenda would be public participation. There's no public in attendance or signed up for participation, so we can move on to number 3, which is our policy readings. We have one first reading. It's policy 8660, incidental transportation of students by private vehicle. This item was in discussion during our last committee meeting, and so as it's here for a first read, if it is the will of the committee, we will move this forward to our next board meeting for a second read.
So move.
As the other committee member, then we will move on to roundtable discussion, or is there more discussion? Sorry, I am confused. Okay. Is there any other discussion? Okay, thank you. Section 4. The first item in roundtable is Senate Bill 29, Section 4.01.
So this in addition to House Bill 214, were both discussed at our last meeting with the caveat that we had not yet received the Neola update that would be required for us to enact a policy that is cohesive with these two pieces of legislation. Neola still has not come out with an update with regard to both of these items. So therefore, it's a legal suggestion that we wait for Neola, and when it's updated, we'll present that. So for now, I believe it should stay in roundtable.
Yes, Mr. Henshaw.
Thank you. If we have just 10 minutes to spare, I've actually prepared some stuff around Senate Bill 29. To your point, yes, Neola, we're going to wait for Neola to come out before we make any policy changes, but I kind of just wanted to review the two amendments that's came aboard with Senate Bill 29, and then the 3 sections that's been enacted. So Senate Bill 29 was signed by the governor July 24, 2024, and it's effective this coming October 24th of 2024. So I've been following this bill pretty closely since its first inception, or since its first excuse me, changes back in November of 23. I provided you all a copy of the entire Senate bill. So I just want to kind of navigate you through each of these 4 areas, and then I'll talk a little bit out and see if you guys have any discussion or questions. And then, again, our recommendation is going to be wait until Neola pushes something out, and then we'll bring back to the board some policy changes around this. But I want to give you guys some information ahead of time. So with that being said, if you want to go to page number 5, this is the first amendment that's made. And this one's a very simple and straightforward one. It's basically stating educational support services data as defined in this section, which we'll get to that section here in a second because it's a definition section. It's basically stating anything that follows under this category is exempt from the definition of a public record per the Ohio Public Records Act. And then we'll go over that definition here shortly. So that's just a small amendment with this change. So if we want to go now, navigate to page number 19. Number 19 outlines the second amendment in Senate Bill 29. I'll give you just a second to navigate to page number 19. And if you look 3/4 of the way down on the page, you're going to see the underlining. So this is anything that's underlined are amendments or enactments in the Senate bill. So this is in reference to section 3319.31. And what this is saying is the addition is using or releasing information that is confidential under state or federal law concerning a student or a student's family members for purposes other than student instruction. And if you look at the top, what section 3319.31 is, it states that for any of the following reasons, the State Board of Education, except as provided in Division H of this section in accordance with Chapter 119, Section 3319.3311 of the Revised Code, may refuse to issue a license to an applicant, may limit a license it issues to an applicant, may suspend, revoke, or limit a license. So that's basically saying that you can't share student data out. They're just putting that provision in there specifically stating that. And if you do, the state board has the right to revoke, suspend a license. Again, a small, simple change. The more the 3 enactments that's coming up has more substance to it. And so let's go ahead and let me stop there. Any questions around those 2? Those 2 are pretty straightforward. No? Okay. Let's move on to talking about the 3 enacted pieces of Senate Bill 29. So let's flip over to page 21. And I won't read through all of the definitions. We'll kind of have more of an in-depth discussion whenever Neola pushes out those policies. But on page 21 at the very bottom, section 3319.325, 326, and 327 are your 3 enacted sections. The 325 is a listing of definitions that will be used in the latter 2. So it's basically defining what an educational record is. And then so that's the entire bottom section of that page on page 21. And if you go over to page 22, it gives you a couple additional definitions. What is educational support services data, which is what I was talking about, referred to the Public Records Act. And then C, school-issued device. That one's overly broad, but a school-issued device, whenever you say that, you're thinking about a Chromebook or a hardware piece, and it's not actually. It's more broad. School-issued device pertains to hardware, software, accounts, anything that's associated to a student. So I just want to point that out. Defining D defines what a student is, and then E defines what a technology provider is. Again, that section is just defining what's coming up. Now, if we look at section 3319.326 halfway down the page, this is really around how we protect data within the district. And I won't go through and read this entire piece, but I want to point out some prominent items within. If you look at, so under that subsection C, it states unless renewal of a contract is reasonably anticipated within 90 days of the expiration of the contract, the technology provider shall destroy or return to the appropriate school district all educational records created, received, or maintained. So 90 days is a limit. So what I typically do whenever I'm reviewing contracts from technology, I consider 90 days is too long of a length. So I like to look at 30 to 45 days within my reviewing of technology provider contracts, but they have it in law. Now, again, this is going into law October 24th. You have to have at least 90 days. You have to have that stipulation in technology. If we part ways during a contract, they have to destroy our data and provide us copies. I think that's too long, so I typically make sure it's written in there 30 to 45 days with our technology contracts. And then taking a look at E, at technology, this is again just putting it out there, technology provider. So whenever you think about technology provider, that's the definition up there. You're looking at eSchool. You're looking at our curriculum products that we share data with, and we have data contracts with them. E outlines a technology provider shall not use educational records for any commercial purpose, including but not limited to marketing, advertising to student and parent. Again, just want to kind of point that out. We have parts of this in our policy now, but with the updated language, our student acceptable use policy, our staff acceptable use policy, and our information management policy, we're going to have to make some minor tweaks. I'm sure that's what Neil is going to advise us on this. With that being said, if we move over to page...
Madam Chair, I have
Yes.
a question here. So under C, where you noted that within renewal of the contract is reasonably anticipated within 90 days, you indicated that as a rule here in this system that you do it less than 90 days?
Yes.
Also, so now that we have it within 90 days, are you saying you're still going to do that less than the 90 days?
Yes.
And so if a vendor come back and if someone questioned that the state law is now saying 90 days?
That's a good question. I'll have to relate that to legal. But I'm still going to advocate on the 30 to 45 days. It does state in law 90 days. I think 30 to 45 days is a reasonable request to making sure a reasonable amount of time to make sure that as we part ways from companies, but I'll make note of that and rely that to ask that for legal.
Madam Chair, I'm sorry, I didn't get your name.
Oh, I'm Zach Hanshaw.
Zach Ancho. I mean, so now it says 90 days. So if you are requiring something less, then I can tell you already that's a problem because it clearly says within 90 days. If in the event that someone comes and said, I had 90 days, and you're saying it's less than 90 days. So I'm just saying, this is a law.
Yes.
And we don't make this law. The legislators do. And so they've made it.
Okay.
And the attorney, you may want to, what do you
Yeah,
think?
we'll wait for Neola to
Yeah.
have the update, and we'll rely on that, I'm
Well,
sure.
it's
but-
not just Neota's
no, it's
update.
not.
It is the practice of this district. And the practice of the district, you're saying, is going to be less than what the law says.
So we can, with that being said, whenever this is enacted on October 24th, 2024, we can go and make sure that the 90 days is the requirement on the new contracts.
Yes, that's what I'm saying. I mean, you may want to make it less and ask them to do it less,
Yes.
but if somebody questioned it,
Then it would be
they
90 days.
Then it would be 90
Correct.
days. That's what I'm saying.
Agreed.
Yeah.
Okay. So if we move on to page 23, want to point out section or subsection G. Not later than the first day of August. This is the big piece of the Senate Bill 29. Not later than the first day of August of each school year, each school district shall provide parents and students direct and timely notice by mail, electronic mail, or other direct form of communication of any curriculum, testing, or assessment technology provider contract affecting a student's educational record. This notice shall do all of the following. It gives you 3 items that it should list. So what we're going to do by October 24th is have a communication piece out of all of our technology products that it's associated to the educational record. So, and then no later than the first, since this bill is not enacted yet, it enacts on October 24th, we'll have that first communication to go out. And then by the first day of August for next year, for example, and every year thereafter, we'll have that same listing go out. More than likely, it'll be part of the parent handbook. That's going to be my recommendation as part of the parent handbook of showing these are all the educational technology records, or all the educational technology and curriculum that we have as a district, and just a notification to the parents, this is what we are using. Okay, moving further down, so about halfway down the page, underneath of, right below 3, it states each school district shall provide parents and students an opportunity to inspect a complete copy of any contract with a technology provider. So it gives an outline of, I just want to make note of that. If we do get a request, we have to provide the parent or guardian a copy of that contract for them to review. Okay, moving to the last section, so it's section 3319.327. And this one really deals with monitoring school devices around privacy. And it's stating, except as described in Division B of this section, a school district or technology provider shall not electronically access or monitor any of the following. And it gives examples, 1, 2, and 3, location tracking features of a school-issued device, audio-visual receiving, transmitting, and recording features of a school-issued device, student interactions with the school-issued device, including but not limited to keystrokes and web browsing activities. But underneath of that, division or section B, division A of this section does not apply to the following circumstances. And it gives a list of what those 6 areas are. So the activity is limited to a non-commercial educational purpose for instruction, technical support, or exam proctoring by school district employees, student teachers, staff contracted by a district, a vendor, or the Department of Education, and notice is provided in advance. The activity is permitted under judicial warrant. The school district or technology provider is notified or becomes aware that the device is missing or stolen. So, for example, we wouldn't be able to track any devices as it stands. If we get a report that a device is missing or stolen, then we could try to geolocate the device so we can try to recover it. Number 4, the activity is necessary to prevent or respond to a threat to life or safety, and the access is limited to that purpose. Number 5, the activity is necessary to comply with federal or state law. And then number 6, the activity is necessary to participate in federal or state funding programs. Questions, comments? Okay. And then with that being said, so the next item, which is related to, or it's the same section related to notification. So it's kind of at the bottom of page 23. It's number 2. It states that in the event that one of the circumstances described in Division B of this section is triggered, so I'm going over to page 24, triggered, the school district shall within 72 hours of the access notify the student's parent and provide a written description of the triggering circumstance, including which features of the device were accessed and a description of the threat, if any. This notice is not required at any time when the notice itself would pose a threat to life or safety, but must instead be given within 72 hours after the threat has ceased. So with that being said, what we are doing is we're creating templates around notification letters. We're trying to do all the back end work of how we're going to be notifying parents if one of these provisions are activated. So just going back to the example, if a device is reported as lost or stolen and it belongs to student A, then we would have to generate a letter stating that we've tried to access this device and send it out to the parents within 72 hours. So that's going to be the biggest caveat on this. It's going to put a lot of strain and a lot of work on our end, to say the very least. But we're working on a template right now, a letter template that we can auto-populate for these scenarios when they pop up. We're trying to do a lot of the back-end work so that when October 24th comes around, we're prepared. And that's the end of it. So I know right now we're not doing any policy changes. We're waiting on Neola to make those adjustments and recommendations, and then we'll be bringing back those recommendations to the board so we can review.
Thank you. Are there any comments or questions for Mr. Hanshaw?
So when you reported to us about our students and their activity on social media over the summer in the past, would that be applicable to this in terms of us, seeing what they're actually browsing and looking at?
So whenever that was reported, it was reported where it didn't identify any individual student as aggregated at large, and that's allowed under this provision. So it's the time so we have content and filtering that's in the place of the district that we have to abide by with SIPA and FERPA, so that we're blocking sites like pornography, sexual content, etc. And that's under the division here. So all of that is allowed. But if there's ever a scenario where we're accessing an individual student's device, then yes, we would have to report that and trigger that. But anything at large is having aggregate data or non-identifiable data at large, then we'd be fine.
Thank you.
You're welcome.
Are there any other questions? I have a couple. First of all, thank you for this. The background and the context is very, very helpful, and will be helpful for us to look back on when we do receive the Neola and we have the Neola discussion. So I really appreciate how thorough this was, so thank you very much. I have a question here that might just be clarifying a misconception, but that's also an important stage here too. And if you don't know yet, it's okay. But I know a lot of these, especially, I think it was page 21, but it might not be, because that was the educational records. But when you were talking about the things that we cannot report out for companies that we have licenses with as we go through the licensing. But I was wondering how this may or may not apply to free apps. I've always been told there's no such thing as a free app, and if you are signing up for a free app, it's because you are selling all of your data. So how would this relate to free apps?
That's a very good question. So we get inundated with the number of apps. So at large, we block a lot of them. So what it is, we do have a process in IT that a teacher or principal or school reaches out, especially if it's a free app, that like, hey, we want to utilize this in our classroom, and we go through a review process. We review the privacy terms, making sure that they're SIPA, COPPA, FERPA compliant, and making sure that there is a data privacy agreement in place to show, hey, this free app. Now, it's not blocking everything. There are sites that go through. That's the nature of the beast. But that same scenario, anything that's paid for by the district, anything that we contractually have in place, they have to abide by this, to making sure that they cannot use any of our records for any type of commercial purposes. But it is page 22, section E, and the part of the section E also states that the technology provider can, though, use, and that's why I was mentioning to Ms. Autry's point, technology provider can use aggregate information, removing any PII, personal identifiable information, for improving, maintaining, developing, and supporting. So, of course, companies, they want to build upon themselves as well. So they're going to use aggregate data to see how they can improve their products. They just can't use individual data for any specific mark. Like if you go out to Facebook or social media and you go Google something, and then you start seeing advertising up on your page within that same hour, that scenario. So none of our technology providers are allowed to do any of that.
And to follow up on that, do we have a list or do we maintain a list of some of the apps or some of the sites that we have blocked specifically for this reason? Because I know sometimes, as a former teacher, we always had the mindset, beg, borrow, steal, do whatever you can to get your class going. And it can be frustrating when something's blocked and you don't know why it's blocked, but it would be very helpful to know, actually, this site was selling our students' data, so that's why we blocked it. We do know what this is, but we blocked it very intentionally.
We do. Yes. Yeah, we have a variety of reasons, like where if I'm reviewing them, some of them might be a free app, it might state educational, but if you look at the privacy terms, it says 18 and older or not advisable, things like that. Those are ones that are very easy to identify, and we simply block them and make a reason for them. Good question.
Thank you. Are there any other questions for section 4.01? All right, thank you very much, and we can start discussion on House Bill 214.
So as I said earlier, Neola has not come to us with their update yet. We briefly went over 214 during our last meeting, but until Neola provides an update, we don't have a policy to review yet.
I'm sorry, I did move on too soon. The recommendation was to keep Senate Bill 29 in discussion for the next meeting.
So move.
Thank you. So we will keep Senate Bill 29 in discussion for the next meeting, and then, so now the recommendation I hear is to keep House Bill 214 in discussion for our next meeting?
So move.
Thank you. Any other discussion on House Bill 214 at present? Wonderful. Moving on, section 4.03, nepotism and anonymous complaints.
So I believe at our last meeting, Dr. Molinar inquired about what policies we might have on the books that address nepotism. We can start with. And there is a conflict of interest policy that you have in front of you. It's policy 1130, and if you go to the second page, section C, there's a paragraph which states employees, officers, and agents cannot participate in the selection, award, or administration of a contract supported by a federal grant/award if he or she has a real or apparent conflict of interest. Such a conflict of interest would arise when the employee, officer, or agent, any member of his or her immediate family, his or her partner, or an organization which employs or is about to employ any of the parties described in this section has a financial or other interest in or a tangible personal benefit from a firm considered for a contract. So that is the policy that addresses nepotism as far as the administration, when there is also a board policy that addresses nepotism in the bylaws, that's board contracts. But I believe this is the most relevant one.
Thank you for bringing this. I will open the table for discussion before I have any comments. Does anybody have any comments or questions at present? Okay, thank you. I do have a question because you mentioned section C. It says employees, officers, and agents. And you said board members have a separate policy. So this basically covers anyone in the entire district?
That's right.
Yes, okay. And then this is administration of a contract supported by a federal grant or award. Is it just for grants or other contracts?
This applies, my understanding is that this applies to every contract that the district would award that is through federal funding, if the contract is paid out through federal funds.
Okay, so just only the federal funds and nothing through general fund or any other funding source?
Yes, that's correct.
Okay. So then the disclosure would only be if it is a federal, I'm looking in section E now, any violations for the federal, and that's because it's federal funding?
Yeah, I mean, there are also, I'm aware that there's laws, obviously, around nepotism, and I believe it goes to federal and state funding, but that's something that we would have to look into further. We brought this as a kind of starting point to see what we were going to need to discuss further.
Thank you. Thank you. It's good to know we have a policy on file. It's good to know that we have information here. My question to the committee is this a policy that we would want to look into more? Is this something that we think we need a policy for other types of funding, or just federal funding? What is the will of the committee?
Madam Chair, I think this is pretty inclusive. I think the last line here that says, these guidelines are not intended to be all-inclusive, nor to substitute for good judgment on the part of all employees, officers, and agents. So I think that if there's other policies, procedures, bylaws that may govern employees and board members, that this kind of covers it, especially it's not a substitute for good judgment. So I think in writing this, that's probably what they were thinking, because we can never think about all the situations that we may find ourselves in or employees may find themselves in. But the question is, was it a good judgment? Would the average person think the decision that you made was rational, sound, and professional? And I think this kind of covers it.
All right, thank you. And as a reminder, the reason we brought this policy for review is it was a start for the review because it was brought up in the transition report that this was a need for our district. So we have looked at it, and if there is further discussion, what is the will of the committee, or do we feel policy has been reviewed?
Madam Chair, I think the policy has been reviewed.
All right, thank you. And so we can move on to section 404, update from administration, potential new policies for vendors and independent contractors.
What?
So there is not a policy that that we were able to locate that specifically addresses vendors and independent contractors in and of themselves. I'm not sure exactly what kind of policy we would like to think of the administration to contemplate. I don't know, Ms. Carter, if you could speak to that.
Unfortunately, our labor relations director ended up needing to leave, but he sent me a message, and he said that we already have a board policy on contracts, and that relationship is guided by contract law. He said that vendors and independent contractors are not employees, and the relationship is defined by the actual contract. But we can continue to put this on discussion, because then that way he can provide more information regarding why we wouldn't make this and why we wouldn't have specific policies for vendor and independent contract operators. So he can speak more to that at our next meeting if we keep it on discussion.
Yes, I think since the expert on the matter is not here, it would make sense to me to keep this on discussion. Is that okay with the committee?
Yes.
Yes.
All right, thank you. So then we will have independent contractors in discussion. And now we have unfinished business, section 501, employment of substitutes.
So at our last meeting, this was a policy that we were recommending not moving forward with at this time, and Mr. Duffbaugh recommended leaving it in unfinished business. Again, because Mr. Duffbaugh is unfortunately out today, our recommendation would be probably to leave it in unfinished business until Mr. Duffbaugh can weigh in further to see if we should just take it off, or if we would recommend taking it off altogether.
Madam Chair, board members, the recommendation would be to take it off and let the administration continue to deal with substitutes, because we're guided by what the state allows. And if the state provides further guidance, then we would certainly follow that. But this has to be something that we have to have the flexibility within this to be able to do what we need to do to get subs in within the confinements of what is in Ohio Revised Code, as well as any additional Neola policies or anything that may come down. But the last that we got was very general and specific to, an allowance for us to be able to hire substitutes. And so I think what we've had up until this point has been sufficient and working, so I don't think we want to change any of this.
So are you recommending that we leave it in unfinished business or take it off of the agenda permanently?
I'm recommending take it off the agenda. We can always come back to it, but right now that would be the recommendation.
All right, so committee, the recommendation is to take 3120, employment of substitutes, off of the agenda.
I have no objections.
All right. I have a question. If we took this off of the agenda, where does that leave? I know we recently talked about employment of substitutes in our last meeting. Where does that kind of leave us today?
We're still following the guidelines. So the guidelines right now are still the same as relates to everybody has to have a Ohio substitute license. So the requirements are the same for degree and non-degree. They have to have that Ohio substitute license. So we're still good. The only difference in this particular thing is the pre-service teachers.
Okay.
So that we can wait on that part.
I remember we had a few people come and speak during our regularly scheduled board meetings that they were substitutes and that if we changed our policy that they couldn't do it anymore. Where does that leave individuals in those types of scenarios?
No, they're still be.
Thank you for this explanation. I think this is honestly my last question. So by not changing our policy, it should not alter our sublist dramatically?
It won't alter it at all.
Wonderful. Wonderful. Thank you. That's really, I guess, my question. Yes, thank you.
So potentially a person with an associate's degree, if they meet all those other guidelines, they can still be a sub, just so I'm clear.
That is correct.
Oh.
Okay.
All right, thank you. So now we are in section 6, new business. Does anybody have new business this evening? And with that pause, I will say I have a bit of new business. In our last regularly scheduled board meeting, I did mention about recess. And I asked about our recess policies for the district, and I appreciate the information that was sent to me on recess and that we have. I would like to share that with the committee and with the committee's approval. Since we have taken things off of the agenda and we only have 3 other items for discussion for our next committee meeting, I would like to have a discussion on recess and our recess policies. I have a few things I can share from Center for Disease Control and National School Boards Association about the value for health and for our children and for learning for recess and recess policies. Is that okay with the committee?
I have no objections.
All right, thank you. So I will add recess. And so our policy status review, we have no policies heading to the board agenda for a 3rd and final reading. Our summary, my favorite part. We have 1 policy heading to the board agenda for a 2nd reading, that is 8660, private vehicle. We have no policies heading to our next legal committee meeting. So our next legal committee meeting, as it stands, will have exactly 4 discussion items. It'll be Senate Bill 29, House Bill 214, independent contractors, and recess. So I think that's a very manageable agenda. And unless anybody has any other comments, we can head into adjournment at 6:21.
So move.
Thank you.